All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, guys. So a couple of quick updates on things developing at the federal level. On Monday, the EEOC sent its proposed new guidelines on workplace harassment to the White House for review, which is one of the final steps that will need to be taken before this thing moves forward into being published and becoming effective. As many of the viewers here may recall, the EEOC is in the process of updating and consolidating its guidelines on harassment. The EEOC's existing harassment guidelines are quite old, stretching back into the late 80s and into the 90s. And it's also scattered throughout a number of different documents. So one of the EEOC's goals here is to clean up the issue by consolidating the guidance into one sort of omnibus document. And the result will be a large harassment guidance document for employers that provides some really good practical guidance on what the EEOC views as the law and what kinds of things employers can be doing to comply. The guidance is intended not really as a change in the law so much as a incorporation of more recent developments in this space. We've had a lot happen in the last 30 plus years since some of this guidance has been put into place. You've got the MeToo movement. You've got the Bostock decision extending Title VII protections based on sexual orientation and gender identity. So we expect this guidance is going to incorporate a lot of that discussion. This has been a significant priority for the current EEOC regime. The new guidance was unveiled in the fall, and it received almost 40,000 public comments, and it's moved fairly quickly towards adoption. And so we expect sometime in the next few months that this is going to move forward to becoming, the effective guidance on this issue.
Justin, for anyone that hasn't taken a chance to read all that yet, we usually leave that up to our good friends at Ogletree to give us some insight and guidance. I'm assuming that's going to be heavily weighted with education and training and those types of things as part of the new guidance, where today it's not so specific unless you're in a state that does require, some specific, does have some specific legislation around it. On a federal level, it's a little ambiguous of when and how you must do the training. Is that something that's buried in this that might come out and be new for employers?
Yeah, there's some good proactive guidance on what employers can be doing in order to comply. Certainly training and understanding what your obligations are. And I think it's important to note that this is not a huge change in the landscape for employers. And I would consider this to be more of a house cleaning and general cleanup of, the EEOC's guidance on these issues. The harassment standards are still going to be the same. The same kinds of issues are going to be coming up, but there's a lot of really helpful modern world examples that are in there for what is and isn't harassment. Things like, social media, virtual workplaces, the interplay of those with the workplace. Some of the more modern challenges that are faced by employers are dealt with in this guidance. And so it's not a paradigm shift in the law. It's not going to impose, all these new obligations on employers. It's more of an update to what already exists. Because Phil, I hate to tell you this, and it may come as a surprise, but the 80s and 90s were several decades ago now. So,
are you taking a dig at my gray hair there, Justin?
I certainly would not on an employment, discrimination type issue. But it's hard to believe how long ago the 80s and 90s were. Sometimes, we're dealing with guidance that's 30 plus years old. So this is really intended to bring those up to speed and bring them more into the modern workplace.
Right. Great. Okay. What else you got for us, Justin?
Another issue that's been percolating for several months is the DOL's proposed legislation on worker classification, independent contractor status. And that's set to take effect next Monday. So if you have independent contractors in your workforce, you need to be thoughtful about that. It's right around the corner now. And I think Bert has covered this before, so I won't go into all the details, but the big takeaway is that it will be harder for companies to classify workers as independent contractors. And it takes us back to some of the prior standards that existed before some of the changes a few years ago. It's no surprise that this rule is facing challenges. Independent contractor designation is one of those issues that tends to swing back and forth on the pendulum with changes in administrations. And so this week, a group of Republican lawmakers introduced legislation under the Congressional Review Act that seeks to overturn the DOL's independent contractor rule. This isn't the first time we've seen Congress use this law to try to attack regulations. In fact, 9 CRA resolutions have already passed Congress under President Biden's tenure, and they've all been vetoed. So we don't expect that this is going to, this particular resolution is going to change anything. But what's important to know is that there's also legal challenges to this DOL rule, and there's a number of them throughout the country that are seeking to enjoin the enforcement of it and prohibit the DOL from enforcing it. So those, I think, are the bigger thing to watch out for in this space. It could very well be that this goes into effect, and then in a few weeks or a few months we get an injunction in place or a ruling that says that the DOL can't enforce it, and that will obviously throw things into a little bit of a regulatory upheaval.
Right. So that once again is going to kind of position that HR professional and business leader to, have to make a decision. We know this goes into effect on Monday. There's nothing yet in place that stops it and tells us to do nothing. But then again, there may be some halting after things are in place from an enforcement standpoint. So you're kind of stuck. What do I do? I think the best advice we can give is to follow the rules that go into effect as of Monday. Even though the enforcement on this is being challenged currently.
Yeah, that's certainly the advice that I think we will give, to clients who are facing this kind of issue. Unless and until something changes, I certainly wouldn't rely on congressional, any congressional action to not take actions to comply with this. And, it may be a little bit before we get any kind of injunction or ruling, if one comes at all. So I think the safest thing to do is to comply and to plan to comply with the new rule once it rolls out.
Right. So if you have questions, concerns on that, you can give Justin a call. You can call Bert. You can call our AAIM hotline, and we'll be able to give you guidance on those things and help you navigate those troubled times. It's not necessarily always easy and cut and dry, but again, that's why we're here and we're talking about it and making resources available to you.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/This Week at Work, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.